This is the 5th session of the Federalist Papers Book Club. Again, we remind you at the outset where you can go both for sending us emails, but first of all, here we're going to have a constant YouTube website that you can go to. And if you forget in the future, you can always go back to this, but we'll continue to send out the reminders each week. And then in terms of sending in your questions, we have, as we've played it before, this email address for any questions that you have. And that's what we're going to do tonight, as we've done before, is to start with a question or a comment. So from Peter, I'm having difficulty understanding how pluralism applies not only to religion, but to civil rights and the connection of those two to commerce. Could you give further explanation, please? Well, this is difficult in one sense to give a short explanation to it, but let me start quickly before I go to the next slide with this. You know, generally Americans are against, quote, special interests, but as I tried to point out at the beginning, we're all members of various, quote, factions that are special interests. The big thing today really is that there are large national special interests or factions, but they're organized that way. And so that's part of the problem. And that goes to the nationalization issue. And we'll come back to that. Remember, though, you've got to understand the whole structure and some of the history as to how we got where we are. Next slide. So I put this together as a kind of several points dealing with this. Strong factions, the stronger ones, whether religious, racial, ethnic, or economic, will oppress weaker factions if they're able to do so. The whole point about what Madison is doing in 10 is to minimize that problem. It'll never be completely eliminated, but it's to minimize it. And this is at the foundation. This is really going to the nature of political society, not the structure itself. The structure sits on this foundation or this soil. And that's why it's critical to understand. 2, increasing economic competition, which free market people are certainly in favor of, through commerce among the states and the extended commercial republic, which is a specific contribution of the Federalists, were understood, at least by Madison and Hamilton, although with different emphases, to be tools to break up, multiply, and reduce the relative power of particular factions. Again, I said before, it is a divide and conquer strategy. Factions are bad, but we want more of them. We want more of them so that many smaller ones will be able to control the bigger ones. 3, prior to and even after the 14th Amendment, when the residual sovereignty of the states left them with almost unrestrained police power, this approach was largely effective as to religion and economics, less so to ethnicity, and certainly was not as to race, at least in the South. Now, let me just give you an example. People wonder, you know, what would we have done without federal courts enforcing the First Amendment, religion protections, as we've seen the court doing lately, as against state governors who are not only locking down, but doing so in an inconsistent way that seems to disfavor religious groups. Now, note that that's state power, which of course the anti-federalists think the states should be completely sovereign. But here's a good case where I think some will think, well, you know, maybe it's a good idea that the Supreme Court stepped in. But anyway, the reality is at the founding, there were 9 of the 13 states who had various stages of established churches. The First Amendment on religion, the no establishment clause, was designed so that no one religious group would get a hold of the federal government. That's what the First Amendment was really about. In any event, in Massachusetts, the first real wave of immigration was in the 1840s from Ireland through the potato famine. Now, what a clash you are having. You have Irish Catholics coming in to Puritan Massachusetts. What were the Puritans all about? Puritan came from purifying the Anglican Church. It was too Catholic. They wanted it more pure, getting rid of the Catholic influence. How was it that things worked out? Well, first of all, Massachusetts, under our new Constitution, could not control its borders. They came in. We had no immigration laws at that point blocking immigration. Most states wanted immigration. Well, guess what? Once you get enough, a critical mass, you will always find politicians ready, willing, and able to represent you. And so after a while, this began to change. So in 1852, in the Massachusetts Senate, all but one senator was a member of the Know Nothing Party, the anti-Catholic party. They worked it out over time. Why? Because the system was such that it allowed immigration. They weren't in charge of that. The next slide. So, since the passage of the 14th Amendment and the civil rights laws of the 60s, this pluralism has reduced the relative power of factions based on race and ethnicity. You know, prior to the civil rights laws and especially the public accommodations laws, you had this racial segregation, which all it did was to create in the South two large factions based on race. And a lot of it was that corporations were fearful of opening up to blacks because they thought that the whites would boycott it. But once it became, quote, forced on them, but many of the corporations actually welcomed it, then they could say to everyone, well, look, you know, we're forced to do this. We are doing it. It's competitive. Now, when the civil rights statutes were enacted, some of the senators were offended that it was being done under the Commerce Clause in part rather than just the 14th Amendment. And part of that was the Justice Department strategy based on the civil rights case after the public accommodations statutes following the Civil War. But it made a lot of sense in terms of the rationale of the Federalists. That is, when you get people to mix commercially, then you're going to find out that they begin to integrate. That's what this is all been about, is about integrating various groups in this country, not just on race, but on ethnicity grounds. All of these groups who otherwise would stick to their own, the way the anti-federalists would like, but instead the economic incentives were driven in there so that it became this commercial republic. Now, this changes somewhat after the Civil War because we get the impact of industrialization beginning before the Civil War with railroads. And fast forward, remember we talked about the progressives. Teddy Roosevelt is trying to break up the trust, the big businesses. Taft comes along, and Taft is responsible for the creation, at his urging while he was president, of the U.S. Chamber of Commerce. Before that, there were just local chambers of commerce. And he wanted it to be a counterweight against labor. And labor arose in a counterweight to the large corporations. So a lot of this you're going to have to look at historically and ask yourself a lot of things about social change. The amazing thing is that this structure continues to work even in the face of vast changes. 6, socialism, as described, while not described in Federalist 10, while not using that term, seeks to reduce the numerosity of factions. Socialism and Marxism plays off the fight against factions. They want factions fighting each other. And in Marxist theology, I'll call it, it's about the proletariat versus the capitalist. But in this country, that didn't work. So they went to racial divisions and tried to get the cleavage there. The antidote to all of this has always been the Federalist understanding of Federalist 10. And that's why I spend a lot of time on this, because people simply don't appreciate its importance. Next slide. We're going to go I'm picking up just the titles here. We covered this in the next slide, but I want to orient ourselves back to where we left off. Truth and axioms. Next slide with McCullough. And we went through this showing how the language in McCullough, it very much follows the language in Federalist 23. Next slide. Okay, so Michael here, Michael Needle, he's raising the same objection that Judge Thapar did from the beginning. So I'm just going to highlight a certain part of it. It also seems to be the predictable consequences of Hamilton's conception of power. Okay, that's essentially what Judge Thapar said. Well, you know, it was going to work out this way because of Hamilton. So instead of answering it, let me let James Madison answer this. Next slide. This is Madison in Federalist 44, which I didn't assign, but in the future I will assign. If it be asked, what is to be the consequence in the case the Congress shall misconstrue this part of the Constitution and exercise powers not warranted by its true meaning? I answer, the same as they should misconstrue or enlarge any other power vested in them, as if the general power had been reduced to particulars. And any one of these were to be violated, the same in short as if the state legislatures should violate their respective constitutional authorities. In the first instance, the success of the usurpation will depend on the executive and the judiciary departments, which are to expound and give effect to the legislative acts. And in the last resort, a remedy must be obtained from the people who can, by the election or mere faithful representatives, annul the acts of the usurpers. Next slide. Okay. Powers. What they've said in 44 is, look, we set up this structure to correct it as best we can, but ultimately it's in the people. And when I hear people complain about the structure, tell me what structure you would have put in place for the Confederacy, that is the Articles of Confederation, when it wasn't working well. What would you have done? It's almost impossible. Even the Anti-Federalists knew that the only other choice seemed to be a unitary government, which everybody except maybe Hamilton was against. Anyway, so powers to carry out responsibilities. Whether there ought to be a federal government entrusted with the care of the common defense is a question in the first instance for discussion. But the moment it is decided in the affirmative, it will follow that the government ought to be clothed with all of the powers. If you give the federal government the power to defend the responsibility to defend the country, you have to give them the power to defend the country. Next slide. No limitation on the authority to defend the country. Again, that there can be no limitation on authority, which is to provide the defense and protection of the community. Now, I'm not saying that the government cannot abuse that authority. Certainly, we've seen a lot of that regarding FISA warrants and other things, but that's what the Congress is there for. Unfortunately, however, the Congress is often interested in other things than what they're supposed to do, and they get away with it because the Supreme Court lets them get away with it. Next slide. There is absolute necessity for an entire change in the first principles of the system. Okay, we've gone through this before about switching from the confederal structure to this new, very different structure. Next slide. This is talking about if the circumstances of our country are such as to demand a compound instead of a single government, a confederate instead of a sole government. This is Hamilton. He much preferred the single. I mean, he wasn't into the structure to the extent that Madison was. Madison really was the one who understood, having read all of the history of political theory. The essential point, which will remain to be adjusted, will be the discrimination of the objects. Again, I come back to objects, and it's the way one has to think. We are not taught generally in schools to think in terms of what I called moral reasoning. It's means and ends reasoning. The end of this slide. The government of the Union must be empowered to pass all laws and make all regulations which have relation to them. What are them? The Army, the Navy, etc. And then commerce. Commerce is the area in which national power, in addition to war, grows. Why? It had to grow. As commerce grows, federal regulation will grow. It's unavoidable because everything from Washington, whatever you do, it's going to have to be uniform. The whole reason to put only certain powers there were that those were the powers that we needed to have uniform around the country. All the others were supposed to be left to the states. We know that that's changed over time, and it is mainly the progressives. Next slide. The same applicable to commerce. That's what I just said. The same must be the case in respect to commerce and every other matter to which his jurisdiction is permitted. So, when Bill Gates was starting in his garage, nobody cared about Bill Gates. Once he was powerful enough to affect other states, then Congress became interested. That's the nature of it. As long as it is merely internal to one state, your lemonade stand is not going to be affected by what Congress does. Next slide. Federal government as the center of information. Well, think about it. When the way we've set the system up, especially in the House, but also in the Senate, it is an information system. We live in an information age. And I try to get people in the tech industry to understand that this is an architecture. It's an architecture for the passing of information. And that's for accountability. Now, again, as we'll see in Federalist 48, Congress is a master at avoiding accountability. And they were happy to disrupt the information system. Famously, John Kerry, but also Republicans would have said the same thing. I voted for it before I voted against it. That is their way of trying to fool people. And they have all kinds of means to do that. Next slide. Careful attention of the people, in respect to all those objects which are entrusted to its management, it will indeed deserve the most vigilant and careful attention of the people. If you're not paying attention, you can bet that there will be corrupt things happening. People today, in some sense, are paying more attention than they did at one time, but certainly not to the attention that was paid in the 19th century. Yes, the government was smaller. You could pay more attention to it. Next slide. The government of a free people, a government, the Constitution of which renders it unfit to be entrusted with all powers, which a free people ought to delegate to the government, would be unsafe and improper depository of the national interest. How is it that the United States is still the only real state in the West? Think about it. What state in the Americas has the ability really to defend itself? You look at Central America, they want to legalize not marijuana, not just heroin, distribution of drugs. Why? The drug cartels are more powerful than they are. There will always be power in the world. There are failed states. Somebody will grab power. The whole point about our government is to have enough power to be able to deal with the changing forms of power in the world over time. Next slide. So this is from David Park, and I'm just highlighting the part down here. Hamilton claims that the government must be watched so that it does not overexert itself. I believe that we have watched the happening throughout history and we cannot go back. Well, I don't know exactly what you mean, David, by cannot go back. Technologically, we cannot go back. Can we go back to the parts of the Constitution that have been modified without an amendment? Well, there is the issue that we have modified the Senate by an amendment. So without an amendment, you can't change that. The question, however, is all of the movement of power to the executive branch, not the president. It's the executive branch. It's the fourth branch. The president actually has very little control over the executive branch. And that's been the case for some time. Next slide. We're up to Federalist 39, and this is going to deal with republicanism and federalism. Next slide. Is the Constitution Republican? The first question that offers itself. Well, on the highlighted part, if the plan of the convention, therefore, be found to depart from the Republican character, its advocates must abandon it as no longer defensible. Here's what the issue is. Nobody agreed on the definition of Republican. Republican, broken down the Latin, is res, R-E-S, publica, the public thing. The one thing they all agreed on was an actual governing monarch that excluded a merely symbolic monarch. But an actually governing monarch couldn't be a republic, at least in the Middle Ages. Why? The monarch owned all the land. The whole thing about res publica is it's ours. It's no longer owned by one person. That's the origin of it. But beyond that, they didn't agree. It's like today, people use the term democracy, and they have in their heads different meanings of what that term means. You can say democracy and mean the Federalist. You can say democracy and mean the kind of democracy that was condemned as socialism, in effect, in Federalist 10. What are we talking about? The most important terms rarely get defined. Next slide. Okay. What he gives here are examples of different places around the world that claim to be republics. Holland, Venice, Poland, and England. I've already touched on England because they only had a symbolic monarch since 1689. Venice was a city-state. Really, it's a trading area, and it was an oligarchy. And I tried to explain this to a law professor, very, very bright guy who is in the economic area, very strong. And he didn't see initially the difference between the United States and a place like Singapore. And then I explained Federalist 10 to him. And then he could see, well, yeah, that's a very different thing. You can have great economic activity, as the Dutch had, as the Venetians had, as Singapore has today. You can do it in a small country, a city-state of it. But you're not going to get the same situation as you get in the United States, where that wealth goes through largely to what was built up as a huge middle class. Next slide. This is Publius's definition of a republic based on principles of government, not by just examples. So we may define, he's defining it, at least for us. And this is what it becomes in the United States. Because when you tell people in the US it's a republic, well, what do they mean? They think, oh, we have representatives. But that's not what the term necessarily means elsewhere. We may define a republic to be, or at least may bestow that name on, a government which derives all of its power directly or indirectly from the great body of the people and is administered by persons holding their office during pleasure for a limited time or during good behavior. Guess what? That definition corresponds exactly to the structure of the Constitution. Now, he admits he may define it this way. Rhetorically, they have to define it this way, but it is a legitimate definition. It does rest on, in large part, certainly for the time, the broad body of the people. From the great body of society, not from an inconsiderable proportion or a favored class. Obviously, the South at the time with slavery was far less Republican than was the North. It is sufficient for such a government that the persons administering it be appointed either directly or indirectly by the people, and that they hold their appointments by tenures just specified. I remember years ago when I was a law clerk in federal court, this woman called up and she was outraged at the judge. She went on, and I just quietly listened. She says, "I'm never going to vote for him again." I said, "Man, federal judges are not elected." She thought that was un-American. No, it's not un-American. It's part of the structure. Next slide. Look, this is very interesting. That is proof positive that we have a republic, he says. We have no nobility, no titles of nobility, and we have a guarantee of Republican government. Now, I've always wondered whether Congress conferring a national title of poet laureate somehow violates the nobility prohibition, but I don't imagine anybody's going to litigate that. But the guarantee of Republican government has attempted to be litigated without real success. Again, in part because nobody really knows the full extent to it. That is, there is no requirement in Republican government that you have two houses. And we know a couple of the states have only one house in their legislative body. But if we had a state, and the closest that ever came to it, I suppose, was Louisiana under Huey Long. If you had an out-and-out dictator, I think at that point, the Congress would step up and say, "You're out of here. You're not Republican." Next slide. The anti-federalist objection, however, was also to the form of federalism, or that it wasn't a confederacy of the states. So he says, but it wasn't sufficient, say the adversaries of the proposed Constitution, for the convention to adhere to the Republican form. They ought to have preserved the Union as a confederacy of sovereign states. Well, yeah, we dealt with that before. No, that's the big change. You're not getting that back. The Union, but they assume, therefore, since it's not a confederacy, which it isn't, it therefore must be a consolidation of states. No, it's not. And now he's going to go on and show you why it is not, or at least it wasn't. Next slide. Here are 5 issues on which to judge the character of the Constitution. So the real character of the government, you have to consider 1, its foundation, 2, the sources of its power, 3, the operation of those powers, 4, the extent, and the method of changing the government. Next slide, we'll hit the first one. So the first one is the foundation, the consent of the people in each state. This is very interesting. The Constitution is to be founded on the assent and ratification of the people of America, given by deputies elected for the special purpose. But on the other, that the assent and ratification is to be given by the people, not as individuals composing one entire nation, but as composing distinct and independent states to which they respectively belong. Remember, in the ratification debate in Virginia, Patrick Henry thundered, "How dare you start 'we the people' instead of 'we the states'?" Well, that was deliberate for this change. What is sometimes lost, because on the original, and I wondered whether it was in the original until I went to the archives and looked, the full caps are on "we the people," and then the states is not in the same font, we'll say. But let's finish this. Derived from the supreme authority in each state. What is that authority? The authority of the people themselves. How? In convention. In the 18th century, that was the most, it was the closest thing to popular consent. It was still a representative form. So the foundation is not national, it's federal. Now, there are those who want to change this. Next slide. The act of the people as forming so many independent states, not as forming one aggregate nation, is obvious from this single consideration, that it is to result neither from the decision of a majority of the people of the Union. Think about that. If it had been decided by a majority of people in the Union, it would have been decided by the cities. It must result from the unanimous assent of the several states. This is similar to the voting pattern in the voting rule in the Constitution Convention, which was related to how the Continental Congress worked. Each state got one vote, that's all. So no matter how many delegates they sent, it was the majority of the delegates from that state that decided how that one vote was recorded. Again, that is a federal dimension. Where the people regarded in this transaction as forming one nation, the will of the majority of the whole people of the United States would bind the minority. That's what they don't want. See, for all of this criticism of the Federalist wants the states as a protection for the national government as well. Next slide. This is from Chief Justice Marshall in McClellan. No political dreamer was ever wild enough to think of breaking down the lines which separate the states and of compounding this American people into one common mass. He didn't live long enough. There are plenty of political dreamers recently and very actively today who, first of all, want to wipe out the Electoral College. And what would you have then? You would have one mass vote. One of the practical reasons for the Electoral College is to minimize the problem of fraud when the counting has to be done state by state rather than, as in many third world countries, by one centralized source controlled, guess by whom? Those in power. Next slide. Second, the sources of the power. Now here, this is important to understand, especially the House, because you may not think of the House this way. We talked about the Senate as being federal, but the House of Representatives is national. Why? We'll go on. The Senate, on the other hand, will derive its powers from the states as political and co-equal societies, and these will be represented on the principle of equality in the Senate. So far, the government is federal, not national. Why is the House national? Because no state has control of its representation other than the minimum guarantee in the Constitution that each state will get at least one member of the House. Beyond that, they are subject to the census. Now, until the 1920s, the way Congress dealt with this was to protect each other's jobs. So what they did was when a state would lose or would stand to lose a representative, they would simply expand the numbers in the House so that whoever was about to be lost from the House got to keep the seat, but other states got more seats. The state's relative power went down, but importantly for the representative didn't lose his at the time job. So that's one thing. And this relates also to the whole business of term limits. Without a constitutional amendment, the states cannot term limit members of Congress. We'll talk about this more as to why that is the case. It was different as to the Senate. But for the 17th Amendment, states would have been free to term limit senators. Next slide. Third, the operation of the government is clearly national. We've talked about this already in Federalist 15. The operation of the government on the people in their individual capacities. That's what it means to have national. But it's national only as to those powers. Next slide. The extent of the government's powers is federal, meaning there's supposed to be enumerated powers. That makes it federal. It's limited. It's not a government of all powers. Now, I realize that the federal government has extended its powers everywhere by manipulating, especially the Commerce Clause and also the Spending Clause, and a progressive Supreme Court has allowed them to do so. But remember, as Federalist 10 talked, Federalist 48 will talk about, if you get one of the branches not doing their job and aligning with the other, you're going to approach problems of tyranny. So many of the things that Judge Thapar was complaining about, it sits at the feet of the federal judiciary. They're the ones that didn't do their job on so many statutes. The idea of a national government involves an indefinite supremacy over all persons and things, so far as they are objects of lawful government. The proposed government cannot be deemed a national one. It still isn't. It wasn't. Look, people wanted President Trump and now President Biden to issue national mandates on lockdowns and other things. They don't have the power to do that. States have the power, arguably, to do it to a certain extent. Why? Health is a matter of the police power. Now, people are free to revolt against that. In a number of states, they are. And they're trying to impeach governors in California, Illinois, and New York. Good. That's self-government as it's supposed to operate. The proposed government cannot be deemed a national one. Certainly in certain enumerated powers only, the states have the residuary and inviolable sovereignty. And importantly, if you can't impeach the governor, remember, vote with your feet, and you can do that. Here in Florida, the influx of population is up by 50% since COVID. That's not tourist population. I'm talking about change of residencies. Next slide. Exception. They're recognizing that the one thing that's not technically federal, but in a way it is when the Supreme Court deals with boundary disputes between two states. Nobody else could deal with it except the Supreme Court. And in fact, on this matter, we have the first model of an international court. As between the states, the Supreme Court is an international court. So, next slide. Fifth, the amendment process. Well, we know how complicated the amendment process can be. It's generally been that the Congress submits amendments to the states and that we haven't had the states doing it, but that's only half the story. Congress often will only submit an amendment to the states when the states come close to the magic number of calling a constitutional convention, and that forces the hand of the Congress, and they come up with the amendment. And again, remember, the 17th Amendment was not driven by Congress. It was driven by the states. Next slide. National, not federal, but a compound republic. So this is a summary of what he's gone through. He's gone through the 5 issues to look at and to see whether it is national or federal. Some are national, some are federal. The Senate today is much more national than it was federal back then. The proposed Constitution, therefore, even when tested by the rules laid down by its antagonists, is in strictness neither a national nor a federal constitution. Here, federal meaning confederal, but a composition of both, called the compound republic. Now, that becomes the new definition of federalism. That's when federalism parts ways from confederal. We have 2 terms now, thanks to our Constitution and the explanation of it in Federalist 39. Next slide. So, Sophia, Madison states that the House of Representatives indicates a national government because it derives its power from the people, and the Senate indicates a federal government. It's not federal government, it's a federal dimension of the government which goes towards the compound because it derives its power from the states. This balance between the federal and the national government seems to be disrupted by the 17th Amendment. Yes, thank you. I've said that many times. I'm glad you pointed out. The legislative power has become national rather than a combination of national and federal like the founders intended. Yes, when you take the 17th Amendment and the 16th Amendment on taxation, you've got an engine for nationalization right there. Those came from the American people and the states. And the 16th Amendment, as I think I mentioned before, came because people wanted to get rid of tariffs. They want and thought the rich would pay the tax, they wouldn't have to pay the tax. Guess what? Didn't work out that way. Next slide. Federalist 45. Okay. First slide. If not individually, does the mass of power threaten the states? Having shown that no one of the powers transferred to the federal government is unnecessary and improper, the next question to be considered is whether the whole mass of them will be dangerous to the portion of authority left to the several states. Note that the way the Federalist has proceeded is extremely analytical. What we just went through, they broke down using the criteria, they said, of the opponents. And they answered it's a very lawyer-like argument. It's almost like an appellate argument, as opposed to some of the arguments made by some of the anti-federalists. I think of Patrick Henry in particular, probably the greatest orator of the time. But he's clearly not an appellate lawyer. I mean, he is an advocate for the juries and the masses, and he's outstanding. But there are different types of rhetoric being used by the Federalists and the anti-Federalists generally. Next slide. Historically, states in a confederacy destabilize the center of power. Okay, to the extent that they're dealing with history, they look at what happened historically. Again, these are clear-eyed individuals. These are not utopians. They're not dreamers. They are about the practical business of creating a constitution. They've looked at theory. They've looked at history. They've looked at experience. And historically, the problem was not that confederations centralized. It is just the opposite, that they either fell apart or one part of it took over the rest. The reality is that political theorists, certainly Hobbes, thought that the idea of a federation was crazy. It made no sense. But the notion of federalism and confederacy actually comes theoretically from the first time from a German whose name was Althusius. And Althusius wants to combat Hobbes. He's against the all-powerful Leviathan. And Althusius and others are out of the Calvinist tradition, and they're tied very much to what we call covenant theology. So much of the influence of certain Protestant theology is very much evident in our notion of first confederalism and then what we get in our new federalism. But it goes back to the Mayflower Compact. What was the compact? It was a compact between the people on the Mayflower and God as to how they were going to function in society. So this has a long history to it that is almost never talked about, either in political science or in law school. The states will remain under the proposed Constitution a very extensive portion of active sovereignty. The inference ought not to be wholly disregarded. And part of it was that the southern states had complete sovereignty almost, except over the Contracts Clause, and therefore could treat slaves the way they did, that they could maintain slavery. Now, you also have to recognize that at the time of the convention, southern states, at least their representatives, thought that slavery was on its way out, and that's where they wanted 20 years to transition, they said. Interestingly, manufacturing, namely the steam engine and the cotton gin, the steam engine for the steamboat, all of a sudden made slave labor extremely profitable after the convention. And so the idea of getting rid of slavery became opposed by those who were profiting very heavily from it. Next slide. The advantages of the state governments. And if the state governments have lost the advantages, it may depend on the state you're in. The state governments will have the advantage, it says but it should be over the federal government. Whether we compare them in respect to the immediate dependence of one on the other, to the weight of personal influence, which each side will possess to the powers respectively vested in them. The predilection and probable support of the people to the disposition and faculty of resisting and frustrating the measures of each other. Certainly at the time, people were attached much more to to their state governments. In fact, remember that John Jay, co-author of the Federalist, left the position of Chief Justice of the U.S. Supreme Court to run for governor of New York. Okay, that shows you also, first of all, the status of the Supreme Court. Jay said that this institution would never amount to anything. He was right as long as he was Chief Justice. That's true. But once Marshall came on, it was a wholly different matter. And Marshall understood, in particular, what we're going to talk about when we get to Federalist 51. He understood what each of the branches was supposed to do. So Richard Epstein did a great lecture a couple of years ago after Bellow, in which he talked about times when people are more attached to the federal government and times when they're more attached to the state government. And when people lose trust in the federal government, as many have, say over the whole takings issue, they reflected by changing and strengthening the laws against takings or protection for property in their own states when the Supreme Court wouldn't do it. And that's perfectly proper. But at other times, the attachment has run to the federal government. And Hamilton wanted that to occur, and he thought it would occur if the federal government was actually well run. And for many years, it was well run. But not too many people who have any experience with our government, whether you're talking about a Republican administration or a Democratic administration, would call it well run. Why? They're doing way too many things never supposed to do. They were given the most essential tasks that the states couldn't perform. And they were supposed to perform for the states. But they went well beyond that, and that's the mess we're in today. Next slide. The states are constituent parts of the federal government. Well, I've said this several times, and it really is important to understand how that shifts the balance when that changes. Just think about it. On taxes, what the anti-federalists feared at the outset was that the feds would suck up all the tax money. Well, they sure do today. As long as they both had taxing powers and that they could compete with one another, it was in the interest of state legislatures to instruct their senators to keep the taxes low so as not to suck it out of them. It was the competition. Note, everywhere it's competition and conflict. It's conflict between the three branches we'll see. It's conflict between the state and the federal government, or at least it was. So all of these things were key to an understanding of human nature. And when people don't realize that because they've never been exposed to the Federalists, they don't understand what has been put in there, why it was put in there, and what's happened since some of it has changed. Next slide. Powers delegated to the federal government are few. We've heard that said over and over. Those of the states are broad. But just take some examples. So the police power is still in the states. 95% of all criminal prosecutions occur in the states. Only a relatively small number occur in the federal courts. Now, there are a number of reasons for that. For one thing, we don't have enough federal judges, and we don't want enough federal judges to prosecute all these cases. Two, the federal government should be, although it is not, limiting itself to only those things that it can deal with that the states can't deal with. Much of my time is spent on the over-federalization of criminal law. What the feds have done, distorting the Commerce Clause, is to use it as a hook to justify over 5,000 formal crimes, not to mention the several 100,000 criminal penalties that are attached to administrative actions. What the feds want really is a superintending power over the states and criminal justice, just as the federal government has a superintending power over commerce. But it has no general power. It's totally unjustified. But people don't object. Why don't they object? One, we went through the law and order phase of the 70s and 80s. And so members of Congress were passing statutes because people wanted more law and order. Never mind that none of the statutes they passed had any effect on it. But what it did was to increase federal power in the Justice Department in a way that is amazing since the 1970s. The powers delegated to the proposed Constitution of the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. This is Madison and Hamilton earlier in 23 saying the same thing. These are supposed to be limited. The former will be exercised principally on external objects as war, peace, negotiation, and foreign commerce, with which the last power of taxation will for the most part be connected. That is, it was on tariffs. The powers reserved to the several states will extend to all objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the eternal order and improvement and prosperity of the states. In 1968, when Richard Nixon ran for the presidency, he talked about a lot about the silent majority. Well, the Federalists expected the majority to be largely silent at the federal level because they weren't interested in most of the issues, but that they should be very active at their local issue level. It was only over time and gradually as federal power increased, and was especially apparent in certain Supreme Court decisions on prayer and abortion, that the Supreme Court managed to wake up a sleeping giant that had been sleeping very peacefully and simply not concerned about national politics. You know, the Supreme Court was able to do something that none of the religions have been able to do, and that is to get Catholics and Baptists to work together. It would have been totally impossible but for the Supreme Court. Next slide. The federal government strongest in war. Well, that's natural, and we want it that way. The problem, of course, as I mentioned before, is that after a war, people want to go back, but those in power don't want to completely go back. After World War II, there were those who wanted to unleash the power of the United States. There were those liberals who said, no, we'll go into a terrible depression if we let it go back and let people actually engage in commerce. We've got to run everything. And there were a couple of different strategies taken by certain businesses. Those that bet on the come, that things would get much better, they're the ones that prospered. Those that bet the other way didn't do so well. So, but that didn't mean that everything went back. Harry Truman thought everything continued, and that's why he thought he could use the powers that FDR did to seize the steel mills. But he found out, no, certain powers actually do only exist in a war. When Congress has declared a war, you can't go in and, in an undeclared war, do internally things that only can be done under the war powers. Next slide. Most powers of the federal government are not new. I mean, this is really true. It's just that they were incompetently given in the Confederate Articles of Confederation because people were fearful. They wanted to bring it back. The change which it proposes consists much less in the addition of new power to the Union than in the invigoration of the original powers. The regulation of commerce, it is true, is a new power. But that seems to be an addition which few oppose and from which no apprehensions are entertained. You know, for all the things that the anti-federalists complain about, they missed this one. I mean, if they should have targeted anything, it would have been the extensive control that Congress was given over the commerce. I'm not saying that Congress shouldn't have that power, but if I had been an anti-federalist, and maybe I would have been, That's where I would have targeted. And all the vested in the existing Congress by the Articles of Confederation. Next slide. Okay, from Emily. Talking about Madison, he argues that if the plan of the Union were reversed to public happiness, he would reject the plan. Today, I can't help but wonder how many Americans would consider the federal government a source of happiness. I'm sure that there are many people that agree with Emily, and I'm sure that there are others who, if they can get control, be part of the control, they like it just the way it is. Unfortunately, if you're in Washington, even if you're a conservative, the reality is, if you're a lawyer, your law firm is living off the federal government. That's the reality. It's administrative law. And how many administrative lawyers are going to want to go back and get rid of the delegation doctrine and everything else? They're not going to want it. It's going to cut their salaries tremendously. And it's the same thing in criminal law. Why can't you be Federalist? Because when former assistant U.S. attorneys go to the defense side, all they want is a more level playing field. They don't want you to eliminate all these crimes. You eliminate the crimes, you put them out of business. The reality is that the system, and I'm sorry I didn't have this quote from the Federalist early on, where they point out that if legislation is too voluminous, two things happen. One, you really don't have the rule of law because people can't know what the law is, and that's where we are. But two, the shrewd do well, and ordinary Americans don't do well. They don't have access to the information, and I think many people understand that today. Next slide. The Republican government described in the letter as both national and federal features. There is a careful balance between the different needs. This is a unique system, but America is a unique nation. This unique Republican system carefully balancing interests. That is what no other so-called democracy does. Nobody does this. And that we have people in this country who say that this is outmoded, it's 200 years old. It's an argument that is deliberately false in order to advance centralization of power. Centralization of power benefits those who are in power, not those under it. I think that may be the last slide, except for a reminder. Okay. If you have questions, comments, I try to provoke you a little bit tonight. Hopefully you will email something in, your questions and comments, to the Federalist Book Club at gmail.com. And thank you all for joining us. And next week we will take up 47, 48, and 51. That is the core of separation of powers, and then the last of the general that brings the whole thing together. Thank you.